It's a good question. Assets can be put at risk in many different ways. For example, many of our clients have professions where the work that they do potentially exposes them to liability. So for example, if you're a business owner and you have employees that are representing you in the community, if they're driving company vehicles, they're potentially exposing you to liability. If they're in an accident and that accident causes harm or injury, then liability can follow that when they're acting within the scope of their employment. So, if you're a doctor performing surgeries each week, you're potentially exposed to liabilities if something goes wrong. If you're the owner of an engineering company and you're designing buildings, you can be exposed to liability if something malfunctions and, harm is caused. There are also situations where we have many clients, let's say one spouse has lost their companion and decides later in life to remarry. And I don't mean to suggest that your marriage partner can be a creditor, but sometimes in remarriage, depending upon how you title those assets, you can expose those assets to the liabilities of a new spouse. And so what we do as estate planning attorneys is try to make our clients aware of these issues, and we suggest solutions for those problems. There are many different things that we do to protect assets. In Nevada, one of the real effective estate, or I should say asset protection devices, is what we sometimes call a self-settled spendthrift trust. It is a trust that a client can create. If it's done correctly and administered correctly, they can contribute their assets to that trust. They can enjoy the benefit of those assets. They can participate in the management of those assets. But at the same time, those assets can be protected from the claims of unsecured creditors. So Nevada offers our clients many opportunities to protect their estate.